Good morning, everybody. I'm Andy, Business Development Lead for DPAS. This morning, I'm excited to introduce those gods of the data privacy compliance world, Ralph and Rowena. They'll be discussing the Data Use and Access Act. That's the DUA Act, if you want to say it more simply. I believe this webinar has got one of the highest numbers of attendees on record, but we'll get Jordan to verify that later on. Before they begin, I'd like to remind you about some of the training and consultancy services that we provide at DPAS. Of particular relevance, we have our one-day course about the DUA Act itself. Other courses include our BCS Foundation in Data Protection, a 3-day course, ideal for anyone just getting to grips with the world of data protection compliance. For the more experienced practitioner who perhaps already has this full array of qualifications, we have our 2-day CPD accredited effective data protection officer course. And other services that we provide include our market leading SAR processing services, our outsourced data protection officer services, website compliance, and things like information security audits. And you're welcome to contact me, Andy Ledger, anytime about any of those services or training. If we just move on to the housekeeping slide, please. Okay. So if you've got any questions during the session, please use the chat function and we'll attempt to address them during the session. We'd really encourage you to put your questions in. It does actually bring the webinar to life if people actually share their thoughts and questions with us in real time. The webinar is being recorded, so if you missed something, you can watch the recording later. We're going to finish at approximately 12 o'clock. We will be sending up all the webinar materials, including slides, additional resources, by email in the next few days. And also, there's a survey for people to complete. We really do value your feedback. It helps us to plan and understand what you want to hear about in the future. So please take a moment when the session's finished to complete the survey. And now, without further ado, on with the show.
Well, good morning, everybody, and welcome to a little talk through the Data Use and Access Act with myself and Rowena. Just to do a little bit of introductions for those people who don't know us on the call, before I hand over to Rowena, who has, I must admit, done all the work on this webinar and put together the material for us. But for those people that don't know, my name's Ralph O'Brien. I've been a data protection aficionado, geek, nerd, whatever you want to call it, for the past quarter of a century now. There we go. So it could be all I've got to teach you today is how not to be me. We have made all the mistakes, so hopefully you don't have to. But here we're dealing with something a little bit new. So it's going to be my pleasure to walk you through some of the changes within the Data Use and Access Act. And I'll hand over to Rowena and she can take it from here.
Thanks very much, Ralph. So if you don't know who I am, my name is Rowena Fielding. I'm a freelance data protection consultant. I also run DPAS's data ethics training workshop day. And while it's true that I put the slides together for this, most of my knowledge actually comes from Ralph's work preparing to design and deliver the one-day Data Use and Access Act course that he runs for DPAS. So it's very much a collaborative effort. So yes, we've been digging into this legislation, reading various bits and pieces from various sources about what it means, what it says, what it's going to do. And so we've put together this little session for you just to clear up some of the misconceptions and myths that are flying around, to highlight some of the areas that we think are going to be most significant. Obviously, we don't have any kind of crystal ball equipment, but based on our knowledge, and yeah, hopefully to get some feedback from you and to keep you entertained and informed. So yes, on with the show. We're going to cover the myth busting. We're going to cover the significant brackets, as we think, changes, and what to do next. So myths about what the Data Use and Access Act even is. Seen a myth going around in the font of all mythical nonsense, LinkedIn, from people people claiming that the Data Use and Access Act replaces the UK GDPR or replaces the Data Protection Act 2018. Ralph, would you like to explain why this is not true?
Yeah, well, at the end of the day, it depends on the way you view things, and that we had a good regime already, in that we inherited from the days in the EU, obviously the GDPR, and then Data Protection Act 2018, and from the Privacy Directive in the EU, PECR, or the amusingly titled PECR, from 2003. So we've kind of got this unholy triad of law where we've got the modified UK GDPR that's been modified a number of times, actually, when you look at Brexit, when you look at amendments that have been brought in by the changes when we left the EU to create this sort of UK version. So we've kind of got this framework of now three laws. We've got the Data Protection Act 2018, we've got PECR, and we've got the UK GDPR. Now, in my opinion, if you wanted to be brave and you were the UK government and you wanted to, shake up the legislation, why not amalgamate? Why not take, three different pieces of legislation that all kind of interact with each other in very odd ways and create something completely new and brave, and let's get out there and let's completely revamp the UK's laws that protect individuals and the protection of their personal data. So I look at this somewhat of a missed opportunity, because what the UK essentially has done with the Data Use and Access Act is produce an act that does a number of different things. It's actually got 8 parts. And some of those parts have got nothing to do with data protection. There's stuff about creating an underground register of what's underneath our feet. There's parts in there about data validation companies and using non-personal data. There's stuff in there about digital identity providers. So there's a huge amount in there. We're going to focus on parts 5 and 6 that really look at the changes to the data protection regime. And what they sadly really do is create essentially a load more track changes. They create a load of track changes to the 3 existing laws, the UK GDPR, the Data Protection Act 2018, and PECR 2003. So, but they don't do it yet. And I think that's what's interesting about the facts on this sheet. Don't panic, as Rowena has put up in a wonderful meme there, because actually all of these provisions lack secondary legislation at the moment, which is going to commence them. So over the next, I think we're saying 2 to 12 months roughly, we're going to see DSIT, the Department of Science, Innovation and Technology, gradually bring these changes into law. So at the moment, carry on with the UK GDPR, the Data Protection Act 2018 and PECR. And essentially what we're going to do over that next 2 to 12 months is introduce these track changes to create another layer of exemption, complication, amendment, simplification, clarification. Yeah, it depends whether you read the UK government guidance, whether it's clarification or simplification, or whether you're us and it's another layer of complication and exemption. It does depend on who you listen to, but essentially the current 3 laws aren't going away. All we're doing is adding to them with a layer of track changes. And generally, I recommend looking for something called a Keeling schedule. And actually, our colleagues at Bird and Bird have been, first out the gate in producing really good schedules that show the track changes between the existing law and what it's going to look like once all the law parts have commenced.
Yeah. So to sum up, this isn't a major set of changes to data protection law. It's a whole heap of niggling little amendments, changes, tweaks, clarifications, etc. And it doesn't all hit at once. Only one of the provisions comes into effect immediately, and that's one of the clarifications. And that is that when a data subject makes a data subject access request, you have to do a reasonable and proportionate search for their information.
Which you could argue is what was in the case law and the recitals anyway.
Yeah, so this just takes precedent and recitals and formalizes it in legislation. If you're already doing reasonable and proportionate searches, nothing to worry about. Okay, myth number 2. This is a fun one. I've seen this flying around in digital marketing circles specifically, but also among some of the data protection community. The myth that the Data Use and Access Act makes web analytics cookies and trackers now exempt from consent. So this is a PECR change, not a DPA 18 UK GDPR change. And it's a Recital 6, Regulation 6 PECR change, which deals with confidentiality of communications. Now, it's not anywhere near as broad as that. So hold your horses. If you hear your colleagues in the digital marketing sector getting enthusiastic about this, do please offer them this clarification, set them straight. The only types of web analytics cookies and trackers that will become exempt from consent are those which are privacy safe. So those which do not involve profiling individuals, surveilling them across the entire internet, retargeting them for marketing purposes, that sort of thing. So sorry, Google doesn't count.
Yeah.
But Matomo, for example, the privacy safe web analytics platform, that would, providing that you configure it correctly, that would qualify. So only web analytics cookies that are to do with the performance of the website, or cookies that are to do with features requested, actively requested, not just dumped upon the site user, to do with accessibility or region settings, those can now be set without consent. However, they still have to be explained.
Yeah.
So the key there is privacy safe.
So we've still got the existing piece of legislation, which is the UK GDPR, that says, hey, you've got to be transparent if you're going to collect personal data on people. If you're going to use personal data cookies, you've got to tell people. So so there was a lot of talk in the DPDI, the predecessor to the Data Use and Access Act, about we've got to make it much easier for everybody to use cookies, and we're going to get rid of all these horrible cookie pop-ups. Well, no, the horrible cookie pop-ups are here to stay. But what we've now done is introduce another layer of complication, because we're used to seeing marketing cookies, which you're going to require prior opt-in consent for. We're used to seeing analytical cookies, which you need prior opt-in consent for. And we're used to seeing strictly necessary cookies that you need to tell people about, but don't need opt-in consent for. Now what we're doing is introducing a categories of which says using cookies or similar technologies to collect statistical information about how an organization's online services are used, with the aim of improving the service. So a lot of people will read that and go, analytics cookies. Well, yes, but Google Analytics cookies does a lot more than just collect statistics with the aim of improving your service. So as Rowena was saying, there's a big difference between, a privacy safe statistical cookie and, what Google Analytics does, which uses its information for a lot more purposes than just improving the service. So in essence, we've created almost like a subcategory of analytics cookies. There's also another myth going around about server-side cookies, server-side
tracking.
Tracking, apologies. That won't need consent. That's a load of rubbish as well, I'm afraid. So
yeah, most server-side tracking uses tracking pixels. When a tracking pixel is provided to a client device, then the pixel is placed on it's written to that device's storage. So it's exactly the same as a cookie, even though it's not a text file. It doesn't work in quite the same way. So yeah, server-side tracking is not a get out of jail free option for bypassing confidentiality, privacy, and data protection. Sorry.
And Emma has put up a really good question in the thing that, people also need the option to opt out, even if you are doing the cookies that are exempt from the opt-in. So not much is changing in terms of in terms of cookies. If anything, we've created an extra category, almost like a subcategory to more general analytics cookies.
Yeah, you're going to need to be vigilant about the myths and misinformation that's flying around, because as we all know through working in data protection, like Churchill said, a lie can get halfway around the world before the truth has got its boots on. All right, so the next myth, and this is a big fun one that I again have seen doing the rounds on various platforms, is that now that there are recognized legitimate interests and compatible secondary purposes, nobody needs to do a legitimate interest assessment ever again. Tell us why that's rubbish, Ralph.
Well, I mean, it is one of the sort of the biggest changes, I guess. And this is a change that hasn't commenced yet. There was a lot of talk about what would be a recognized legitimate interest and what would be a compatible secondary use. So these are two separate changes, but actually the list is very similar. So what they've done is they've created a new legal basis. So before legitimate interest, they've inserted a EA in your list of A, B, C, D, E, EA, F. And the EA in our list at Article 6 for the legal basis is a recognised legitimate interest. And the idea behind these recognised legitimate interests is that you won't have to do as much homework because everybody is using data for using the legal basis of legitimate interest in this way. The list is quite small. It does talk about crime and disorder. It does talk about safeguarding. It does talk about vital interests. And I actually find it quite repetitive of what's in some of the other legal basis anyway. Legal obligation, public interest, vital interests, national security, which there are exemptions for. So there's a really narrow list. And so to me, the idea of these recognised legitimate interests, again, was about getting rid of paperwork. It was about saying in the original data protection and digital information, it was like, let's get rid of the paperwork. It's an undue burden on people. So let's come up with a list of legitimate interests where you don't have to do an LIA because everybody's doing it anyway. The only thing I would say is you've still got to follow the principles. So you've still got to understand what your purposes are, what your secondary purposes are, if it's a compatible secondary purpose, and it doesn't legitimize anything that breaks the principles anyway. So you're still going to have to do your homework to understand if the processing is fair, if the amount of data you're sending or using is excessive, if you've not been transparent, if you're not being secure, if you're not getting rid of the data. So I don't think this kind of lessens the burden on us, because you're still going to have to make sure your processing complies with the principles and doesn't harm the rights and freedoms of data subjects, regardless whether you need to do an LIA or not. So does it lessen the burden on us for these purposes? It certainly makes it easier to share data and use data for these fairly restricted purposes. It certainly makes it easier to say to individuals or that, hey, you're giving us data for this primary reason, but then we're going to go on and use it for these other secondary reasons. But I still think you need to do your homework.
I think the biggest change from this is that, from what I can tell, and do please correct me if I'm wrong, the new lawful basis of recognised legitimate interests does not carry the same rights as legitimate interests unusual. So, right to object, right to be told what the interests are. those no longer seem to apply. So I suppose in a sense that there is an option for organizations to have the loophole to just flat out deny data subjects clarification or objection opportunities on the basis that they can claim recognized legitimate interests. But again, there you have the difference between doing the bare minimum for cosmetic compliance and upholding people's rights and freedoms, and with a wealth of maneuvering room in between. So while it doesn't necessarily open the floodgates for a whole load of dodgy stuff to be justified under recognised legitimate interests, it may well have implications if you decide that this new lawful basis is a better fit than your bog standard legitimate interests. Implications for the processes and procedures for handling data subject rights requests.
I think, and this is a very general statement about the entire of the Data Use and Access Act, I think we were having discussions on the course the other day, and I think everyone basically decided the people who are going to do it properly are going to continue to do it properly. But what this law does allow is room enough for people who, let's call them bad faith actors, to try and take shortcuts. Yeah, we're not suggesting in any way this you know that you don't still have to do your homework. If you want to do it properly, you still do your homework. In fact, if anything, I'm going to say if you're an organisation that operates outside of the UK, just keep on doing what you're doing because the EU law still applies and nothing in this derogates away from the EU law. What it does do, however, is allow you these little, and I'm going to call them loopholes. I'm going to call them loopholes. I'm going to call them little areas of wiggle room that you wouldn't get in the EU regime, which bad actors will take advantage of.
It adds friction to data subjects to hold controllers to account, and reduces friction for controllers who want to just skate over the surface of data protection. There's the other thing is that while there isn't necessarily a mandatory requirement for doing legitimate interest assessment with balancing test for the recognised legitimate interests, there's nothing to stop you doing it. And if your organisation feels that that is an appropriate technical and organisational measure for compliance with the regulation and upholding of people's data protection rights and fundamental rights and freedoms, then there's certainly nobody's going to get upset with you, except possibly your colleagues, for saying, actually, we're going to carry on being really scrupulous and scrutinising the processing that we're doing in order to make sure that it does fit this category. Brackets, end of sermon. Okay. Another myth coming in, and this, well, I mean, I suppose it was inevitable because you know, it's a really compelling marketing hook for people selling products and services related to data protection. So there's a change to PECR that brings the enforcement regime in line with that of the UK GDPR as specified in the Data Protection Act 2018. So there's been a bit of messaging going around. Huge PECR fines, which I have to say out loud just because it makes me laugh because I'm such a child. The ICO can now potentially levy monetary penalties in line with those of the GDPR on organisations that do not comply with PECR. Now, how many 4% of annual global turnover or 20 million euros or quid fines have we seen so far in the UK?
Well, yes, exactly. You know, far be it from me to ever criticize our wonderful ICO, but I think it's fair to say that the ICO our current ICO has a reputation of being business friendly. That would be the way I would put it. You know, we all saw the MOD data breach, the super injunction from last week, which involved real threat to human life and ended up with no further action. We saw the ICO's annual report that said that 67% of their things they closed, no further action. 33% of the 42,000 data protection complaints had informal action, which is they wrote a letter, and it's like 0.03 actually percent, almost statistically infinitesimal, actually resulted in any formal informal action, any sort of fine or penalty or enforcement note. And so, but what I would say is actually we do see PECR fines. We do see PECR fines. However, there is no thought process as yet, though we are bringing PECR fines in line with GDPR fines, 4% of global annual turnover or £17.5 million. There is no indication from the ICO. In fact, there's been messaging the other way to say, it was going to be 70k before this, it'll be 70k after this. There's no indication that they plan to use these massive penalties as yet. So we shall see. We don't have a crystal ball, but they do have the power to issue larger PECR fines. The question is whether they will.
Okay. So those were the myths and some of the misinformation that's floating around by probably put out by people who in the best faith have got their sources of knowledge from other people rather than checking the legislation for themselves. And as we always do when we're training or informing on data protection, your best bet is always to go back to the text of the legislation, because fundamentally, at the end of the day, if the case should ever get to court, that's what's going to be looked at. Even ICO guidance, if it conflicts or contradicts with the legislative text, then it is the guidance that will be updated. And we've seen that happen a few times over the past decade. The precedent has reaffirmed the interpretation of the legislative text and said to the ICO, you've got to change your guidance because this is not what the law says.
Anybody who's been on any one of my courses will know, always go to the case law, always go to the legislation, because anything anyone else tells you is opinion. What Ro and I are telling you today, opinion, right? What the ICO says, it's an opinion. It's the ICO's opinion. And we frequently see the ICO's decisions either turned over by the Information Tribunal, the first tier or otherwise, or indeed court cases. So, the best thing you can do is pick up those Keeling schedules and read the legislation for yourself.
Yeah. So, with that having been said, on to the sprinkling of the changes that we felt are significant to the practical day-to-day operations of data protection. So this is our preliminary assessment, given that we don't actually have the legislation in place for most of them to enact the actual changes on the ground. It's obviously not exhaustive because there is a lot in the DUAA, and as Ralph said earlier, some of it isn't really all that relevant right now. Your mileage may vary. So the big one that I think is the big one is the changes to automated decision making. So the automated decision making, the DUAA now basically extends the conditions for processing of special category personal data in Article 9. So where before you couldn't process special category personal data on the basis of it being necessary for a contract with the data subject or negotiations for a contract with the data subject, now you can, as long as there are no humans involved in the processing, which seems to me to be kind of a retrograde step for rights and freedoms. Like you can do this now as long as there's no actual critical thinking or oversight involved. But yes, so this presumably allows things like recruiters to use like the higher view digital phrenology AI that purports to predict how good an employee you'll be by where you look on the screen and how many times you smile. Or perhaps insurance companies doing profiling of people based on their conclusions about other people. But this, I think, is a big thing. So there are some stipulations about safeguards required. For example, the data subject has to be told about the solely automated processing. So this is where there is no meaningful human involvement, but we don't have a lot of clarification on what meaningful human involvement is. So the data subject has to be told about the processing, you know, the why and some of the how, and the what to do if they don't like the output. If they don't like the output, they can make representations about that to the organisation. They can go back and say, hang on a minute, like, how did you even arrive at this conclusion? What's going on here? What did you do to come up with this this decision, which I don't feel is reasonable or appropriate or good? The right to have that decision, the output of the automated decision making, reviewed by a human. Although there are no stipulations on how independent, informed, or incentivized that human doing the review may be, automation bias is a thing. People do tend to agree with what the screen says simply because the screen says it. So I'm not sure just really how strong those safeguards are. They look like a lot of procedural work for not much material, meaningful checks and balances, but you know, just my opinion. So yeah,
about the procedural work. Yeah, I'm sorry to interrupt, Ray. I just want to clarify one sort of thing. Actually, what this really interestingly does, you read the government guidance here. It says the rules were complex to navigate, leaving organisations unclear when they could engage in such activities. So what they did as a result is they deleted Article 22 completely and replaced it with Article 22 A, B, C, and D, which is 3 pages of text. Just to make things clearer. So you've got rid of a statement that says any processing based solely on automated processing you can't do, which was the general prohibition. Not that anyone read it like that. It was always read to say you just had to have a human involved. Now it basically says, a decision is based on automated processing if there's no meaningful human involvement, as you've said. But what that means, human in the loop, human on the loop, human in the loop by exception, what does that mean? And then it talks about if you're going to use automated decision making, really they only care about it if it's special category data. That's what I think is the real change here. It says a significant decision based entirely on the processing described in Article 9 of processing special category of personal data based solely on automated processing. So they're really saying, hey, fill your boots with AI unless it's special category data, and then introduce the safeguards. And I think that's the bit to me that really opens the way. They're saying, forget about, normal data, just only really focus on automated decision making if it's special category data. And I think that is the major change here. That is really difficult.
And it's not clear, actually, I don't think, as to whether or not that, if it's special category data, relates to inputs and or outputs. So if you put not special category data in at one end, but get special category data out of the other end, does that still count? So for example, if you track somebody's movements, so geolocation, it's personal data, it's not necessarily, it's not special category personal data, but you track geolocation, you find that this person visits a mosque or a synagogue or a temple or a church every Friday.
Or a family planning clinic, as we've seen in the US.
Or a family planning clinic, yep, absolutely. Or an STI clinic or a mental health clinic, a whole bunch of places that could be significant, and then spits out a conclusion about that person based on that information. Does that count? if it's an inference, or if it's information that can be used to draw inference, again, does that count? We don't know at the moment. So again, like we said earlier, organizations which are genuinely invested in doing right by data subjects, in demonstrating trustworthiness, future-proofing and operating in EU markets will not use this as a license to do whatever they want without appropriate safeguards. But organisations that aren't interested in those outcomes will. So as professionals, we need to both be very keep an eye on what we're being asked to do and why and by whom. But also as data subjects, we should be very, very concerned and vigilant about how this, especially with the massive push by the government to AIFI everything, feed everything to the data fairy, like NHS records and social care records and benefit claimant records and banking records and everything, to feed that to data fairies in order to produce decision making and outputs. This is something that I personally feel could have a very significant effect on data subjects' rights and freedoms in the UK.
Totally agreed. You look at the government's push towards AI, they're signing with OpenAI yesterday, the memorandum of understanding that they're going to embed OpenAI and ChatGPT in everything they do. This just paves the way for that.
Yeah. So again, if you are invested in doing right, then this won't make a huge amount of difference. If you are invested in moving fast and breaking things, then this provides a lot of loopholes. Okay. Come on, slideshow. Okay, another significant change, and this is a PECR change. We had the soft opt-in for commercial organisations, in that the soft opt-in applied to email address, contact details obtained during the course of a sale or negotiations for a sale to the recipient. This now extends to non-profits. So non-profits can use email contact details where those details have been obtained by the subscriber in the course of expressing interest or participating in supporting the charity's charitable purposes. And there's an argument to say that that might exclude some fundraising activities. And there's an argument to say that that might include all fundraising activities. We don't have much in the way of clarification. We've got no precedent, obviously, in this because this is extremely new. And it's operates the same rules as the commercial soft opt-in, which is you have to be transparent and upfront about the fact that the individual's details will be used that way. And you have to offer them the opportunity to say no thanks right then and there. Not in the first marketing email you send them that they didn't have the chance to object to, but right at the point where you're collecting the email address.
And I think what that means is a lot of charities will look at their database and go, great, we'll email everyone on our database. But actually, because when that data was collected, this law wasn't in place, they didn't offer them with the soft opt-in at that point. I think this is something, the PECR soft opt-in for charities is something, yes, that can be used going forwards, but it won't apply to the retrospective data because the way it was collected. So I'm going to see, I think, a lot of charities go, great, soft opt-in, I can now email people on an opt-out rather than an opt-in basis, will then use that on their existing databases and fall foul of the law, right? And so the big gap or the big concern I see here is charities just emailing everybody out and going, oh, it's now opt out rather than opt in, when actually realistically they can only do that on data they collect on supporters or contributors going forwards, because then they've given them the right level of transparency, they've given them the right opt out, the clarity, the unsubscribe on every email, collected it in accordance. So all those good things that you need to do for for PECR now, got to be for a similar product or service. Remember, it's got to be for a similar donation or a similar one. So this is not the law yet. Emma's just come in and said it's probably worth giving this option now. No, because it's not the law yet. The law has not commenced as yet. So we have to. It's only reasonable and proportionate searches that have commenced yet. So we're still waiting for the Department of Science and Innovation Technology to give us the commencement schedules of when this is going to affect. When this goes into effect, yes, we can then change our processes to use soft opt-in for charities, but that will then only apply to the collection of information going forwards and not our retrospective marketing database, which I think is where people will fall foul of the law.
I would also, having worked in the third sector a lot, I would also caution, do not underestimate the enormous impact this is going to make on needing to configure CRM systems, processes, and content. This isn't a change that can be actioned overnight. Even if you decide overnight, yeah, we're going to, as soon as obviously the secondary legislation and guidance comes in, you can say, okay, yeah, from this point forward, we are going to take advantage of the soft opt-in. Great. But that means going back to your data designs, your CRM architecture, your business and support and management journey processes, and looking at where this has an impact. Because, for example, if you use the soft opt-in and then somebody later declines, they opt out, you cannot then use the soft opt-in again the next time they donate. Once they've opted out, that puts the communications on a consent-only basis. So you can only use the soft opt-in once. You can't do it for like every month you send a donation, therefore every month you are soft opting in. That's not going to fly. So while this might seem like a huge opportunity for charities, and in a lot of ways it will be, really, really important not to underestimate the massive burden of doing this properly. And the implications for the rest of the organization and systems and the resources and cost and time and decision making that's going to be involved in transitioning to this model. It is not going to be simple or easy. There is a huge amount of scope to get it horribly wrong. As I was working in the third sector in and around 2014, when the whole fundraising crisis backlash came up, and the whole reason that became a problem was that supporters hated feeling like they were being bombarded by constant sleeve tugging from all of the voluntary sector organisations they'd ever interacted with and all of their affiliates, constantly asking for attention, time, particularly money. And so what happened was, when the third sector got its act together, pulled its socks up and started taking PECR seriously, while the volume of supporter inquiries and engagement went down, the quality of that engagement rocketed up. So the return on investment was a net positive, because while they were talking to fewer people, they were building far more sustainable and robust relationships, which could then be managed and expanded, rather than the spray and pray sort of carpet bombing. If we spam 10,000 people, then perhaps 3 of them will come back and make a donation once, but then never again, because they're so annoyed at us spamming them forevermore. So yeah, really important that while this presents an opportunity, that opportunity is only an opportunity worth taking if it's going to be done properly. Otherwise, you could end up like really upsetting people and doing the charitable organisation quite a lot of harm.
So
End of
again,
sermon.
again, another layer of complication, very little benefit, very much an opportunity to get things wrong.
Okay, the other really, the really significant change here is that for all of the areas, that's not even single article, this is just general areas with multiple sections. All of these that we have listed, there is a caveat that says the Secretary of State can pass new law that that makes changes to what we've said here, and can basically make it up as they go along without having to go through Parliament.
Yeah, I mean, just going through, recognised legitimate interest says Secretary of State can add to the list of recognised legitimate interest. Compatible second use says Secretary of State can add to the list of what is compatible sensible use.
For
International,
example, political campaigning. The
yeah,
Secretary of State could say that's now a recognised legitimate interest or a compatible secondary use.
Article 11A has been added, which says what is special category data can be added to by the Secretary of State. There's stuff in there about automated decision making that says the Secretary of State can pass regulations to say what is and isn't and won't be covered by X, Y, and Z. And that includes law enforcement as well. Transfer of data to third countries. The Secretary of State can add new provisions to say that third countries are adequate. Scientific research safeguards. The Secretary of State can pass additional ones to say what is and isn't scientific research. PECR, storing information on the terminal equipment of a user. The Secretary of State can make amendments there. All the way through this law, it basically says the Secretary of State, if they want, can add to this list or make it different without the same parliamentary scrutiny we would see, for example, on this act. And I think that to me is the biggest concern, that Peter Kyle, Department of Science, Innovation and Technology, on a whim, can sign in something that says, hey, these are now recognised secondary use. These are recognised legitimate interest. These are exemptions to automated decision making. And to me, that puts the biggest question mark over this entire thing, in that without parliamentary scrutiny, we've now got a member of government who can go, brilliant, we'll do something different here. And it's those Secretary of State can amend bits that I think represent perhaps the most serious concern out of everything we've seen in the law.
And additional complexity, of course, because every time the Secretary of State decides that they want to make a tweak to the Data Use and Access Act, say, for example, in the future, there was an unscrupulous political appointee who had vested financial interests in an overseas AI data mining company, could, theoretically amend the law to say helping this offshore AI data mining company is a recognised legitimate interest, and there's nothing to stop that. Obviously, that's a hyperbolic Bond villain type example, but it's not impossible. So rather than simplifying, clarifying, reducing red tape, making things easier, what this has also done is open the door for reams and reams of Secretary of State makes up their own rules for their own reasons, and you have to check all of them every time you do something in case something applies.
There's no suggestion they're actually going to use these yet, but the possibility exists.
I mean, it's Chekhov's gun, isn't it? You don't hang the gun on the wall in the first act if you're not planning to use it by the third. So yeah, this again, as data protection professionals, this will add another layer of complication to figuring out whether what you're doing is compliant or not. And as data subjects, it further weakens your ability to exercise and maintain your fundamental rights and freedoms, as well as your data protection rights. So I'm not sure it's much of a win, but I guess on the other hand, if you are a data protection consultant, then there's going to be a lot of work coming up in the future. Like silver linings, I guess. Okay.
Just to add that,
keep an eye on time here.
And actually, you're going to talk about it on the last slide. The other thing that I think is particularly big as well is the complaints process. That's something you will have to do. We will have to put in a data protection complaints process. I mean, most
spoilers, we're going to get to
that. Organizations will have this anyway, which is 30 days to respond and deal with their complaint, or 30 days to acknowledge their complaint, even before you deal with it. Now, I think that's fascinating, because you've now got 30 days to acknowledge a complaint, have to have a complaints process, have to deal with that complaint, and the law now says you can't go to the commissioner until you've exhausted that complaints process. And so what you will now have is a month, perhaps 2 months, perhaps 3 months of dealing with the data controller before you're even allowed to go to the commissioner, who is taking well over 90 days to respond to complaints. So the actual enforcement of your rights as a data subject is going to be elongated.
Again, for organisations acting in good faith to demonstrate their trustworthiness, this isn't going to be much of an impact at all. For organisations that are not acting in good faith or perhaps have no interest in demonstrating their trustworthiness, as long as they can gain trust by any means necessary for the benefit, then yeah, this is great. This is kind of opens up the opportunity for a large range of misbehaviours. So that's a bit awkward. So yeah, the other stuff I've put under clarifications. Time will tell as to whether or how significant these may turn out to be. Again, the only provision that is enforced now is that when a data subject makes a subject access request, you've got to do a reasonable search for their data. So that doesn't necessarily mean going through your shredders and trying to reassemble all the bits of paper that have been scrapped. It doesn't necessarily mean going through the tapes that are created for disaster recovery purposes. But it doesn't mean that you can look at it and go, well, our records management is such a mess, we've got no hope of finding most of this data, therefore it's unreasonable for us to ask to do that. So no, we're denying your request. That's not what it's for.
This and the next one, stop the clock for DSAR clarifications, is what we were doing anyway. We were doing reasonable searches anyway. We were going to the filing system, but not looking at everybody's bits of paper just in case, right? You know, we were going to the filing system. We were doing a computerized search. We weren't searching through backups. We weren't searching through random scraps of paper. It's just a clarification of that sort of disproportionate effort argument we've always had. What was in Dello and Mike Ashley. So reasonable searches and stopping the clock if you need clarifications. This was all stuff we were doing anyway. They've just clarified it and made it, enshrined it in law, essentially. Yeah.
Yeah. So there's some changes to this is a really confusing one, so much clarification. So now if the processing of data is for the purposes of scientific or historical or statistical research, statistical research, and you're asking for consent for participation in the research, then that can cover the processing as well. You don't need to get separate consent. And I mean, that is just that probably merits a whole webinar on its own, because that's just mind-bogglingly nuts. So I'm just going to say that and move on from it, because
my personal favourite quote here is references to scientific research means any research that can reasonably be described as scientific.
Yeah, interestingly, there's nothing about the scientific method or the core principles of research or research ethics, things like public good, transparency, agency, rigor, and intellectual rigor. Yeah, nothing about what qualifies as scientific, just if somebody describes it as scientific, then it fits. But I mean, yeah, like I said, there's a lot we could go into with that, but it's not in effect yet, so there's probably not a lot of point not ranting about it now. I just had to, sorry. The legal professional privilege stuff, again, it's just formalizing what was in case law and guidance anyway. There's nothing startling in there, nothing new. It says pay special attention to data protection by design and default for personal data about children. Well, I would say pay special attention to data protection by design and default to everybody's data. You know, saying it must be stronger for children essentially says you can lower the bar for adults, which I don't think is necessarily going to serve anybody's purposes all that well. Complaints process, we've gone through that already. And the thing about international transfers, instead of requiring a data protection regime that is essentially equivalent, now the rule is that the data protection regime in the destination cannot be materially lower. So that is actually a bit of a gap. So instead of equivalent, the burden of proof has shifted essentially. Instead of prove it's as good, it now comes to well, if it's only if it's somebody can prove it's actually really bad.
Yeah, so essentially equivalent means it's got to be roughly the same. To me, not materially lower means that there is a materially lower and a lower, but not materially lower. So it can be lower, just not materially lower. So that is different from essentially equivalent. But again, we yet to see case law or guidance on what those words even mean.
Yeah,
The
not in effect yet.
Yeah, and we haven't covered quite a lot in this webinar, including, even changes to the ICO themselves to become a commission. So there's a whole section on what that might mean for independence. It's also worth mentioning before we close today that yesterday the European Commission came out and said we've looked at the UK's Data Use and Access Act and we think you're still going to be adequate. So
Shock, horror,
that
political,
doesn't mean
commercial
that
organisation.
doesn't mean we've got an adequacy thing yet. Our adequacy does run out in December. It's still got to go through the European Data Protection Board, who are more critical, and it's still got to go through the European Parliament, who may well have objections. But the European Commission, the executive body and the political body who decides on adequacy, so far saying this is all thumbs up as far as they're concerned.
So there you go. So now what? Keep calm and carry on. Don't necessarily rush to change anything. If you are thinking about changing something, first of all, check to see whether or not there's other information you're going to have to wait for before you make any decisions. Make sure that you're designing those changes appropriately instead of just crashing them in to take immediate advantage. Always better to do things properly.
Or do nothing.
Or do nothing. Yeah, exactly. Or do as you would do anyway, which is make sure that your ROPA is fit for purpose, accurate and up to date, that it's actually a useful tool for business intelligence, not just a piece of paperwork for compliance. Review your complaints processes, make sure the people handling complaints know about data protection so that they can recognise data protection complaints. Keep on doing data protection by design and by default. Embed the principles, rights, controller duties, do your supplier due diligence, yada, yada, yada. Keep an eye out for the secondary legislation and IC guidance. Have no fear, there will be plenty of consultancies offering webinars to explain them when they come along. You will have to be living under a rock to not hear about them. And if your organisation is operating in the EU and beyond, then maintain the highest standard that you have to meet across the whole thing, because that way you don't have to run multiple regimes. It's all a lot easier.
Yeah, I totally agree with everything Rowena said there, apart from the complaint side.
Wise man.
Yeah, don't argue. Anything for an easy life. No, no. Apart from the complaint side, there's not much you've got to do. We were already doing a lot of this anyway. What it does do is give you extra room to maneuver should you wish to use it, rather than impose new obligations. But we will have to check that when people do want to use this new stuff, recognized secondary purposes or legitimate interests, that we're prepared with answers to those questions.
Okay.
Such as the answers may be when we get to that point. Okay, so there's a lot
I think
to,
you were
lot to
bang
cover
on
there.
time, both of you, and I think this is probably a good opportunity to wrap things up. The big challenge for webinars like this is to get a debate going, but I'm just looking at all the questions there that have come through, so we could say that the level of interest in that has been very healthy.
I've been trying to answer them in the chat as we've been going.
Yeah, I think
For all
Sorry,
the
carry on,
questions,
Rowena.
the answer is go on DPAS's One Day Understanding the DUAA course, which is delivered by Ralph, because it's very much more comprehensive than the quick coverage that we've been able to provide here.
Thank you very much for that plug there, Rowan. And it saved me the trouble of saying it. Also, because people have attended this webinar, all our training, including Ralph's DUA training, is subject to a 20% discount. So thank you again for your expert input. I hope everybody's enjoyed it and found it as thought-provoking as I did today. Can I ask everybody who's attended, please complete the feedback form. It's very valuable to us so that we can hopefully continue delivering webinars that are of interest to yourselves. And I look forward to meeting all of you again soon. Thank you very much.
Oh, we forgot to thank each other. Thanks, Ralph.
Thanks, Ron.